We have a fantastic speaker here today, Timothy Sandefur, who is, Timothy is a principal attorney at the Pacific Legal Foundation. He resides out in Sacramento, California. And the Pacific Legal Foundation, if you're not familiar, they take on a lot of cases defending private property rights and economic freedom. And Timothy is also the author of a couple different books and a lot of journal articles, and he's taught in law school as well. His most recent book has been published by the Cato Institute, where he's an adjunct scholar. And the book is The Right to Earn a Living, Economic Freedom in the Law. It's also available here today after the meeting. So I just want to welcome here Timothy Sandefur.
Thank you very much for having me out this afternoon. I was telling Francisco, I hate doing speeches in places like this where the view is so beautiful that you just can't look at me. So I'll understand if you're staring off into the distance as long as you're listening to me. I work at the Pacific Legal Foundation, which, although we're headquartered in Sacramento, we also have offices in Washington State and down in Stuart, Florida. And we litigate a variety of different issues: private property rights, economic liberties, but also other things. For instance, I'm representing a plaintiff in one of the constitutional challenges to Obamacare right now that we filed in the Washington, D.C. Federal District Court. My client, Matt Sissel, is a Bronze Star winning Iraq War veteran who, although he volunteered to serve his country, morally objects to being conscripted into serving his country by being forced unconstitutionally to buy a product or service that he doesn't believe he needs. And our case is currently pending in the district court. Also, Francisco mentioned school choice. We've done a number of cases involving school choice plans. In fact, one of my proudest moments was meeting Milton Friedman only a few years before his death to talk about the then ongoing case of Zellman versus Simmons-Harris that was before the U.S. Supreme Court. But what I primarily do at Pacific Legal Foundation is work on our Economic Liberty Project, which is designed to protect small businesses and entrepreneurs against restrictions on their right to earn an honest living without unreasonable government interference. And it's kind of appropriate then that we would be at the James Madison Institute, since Madison was one of the most articulate defenders of this right. In the 1790s, he wrote a wonderful essay called On Property. And you can get this essay online easily and read it. Read it today. It's like 2 pages long. You know, Madison was able to boil down into this brief discussion the most important aspects of how property and liberty relate to one another. And what his point in this essay is that we don't just own things. We also own our rights to freedom of speech and freedom of religion. And we own the liberty that we can then use through our labor to develop our wealth to provide for our friends and our families as we see fit. And so he says in this essay, that is not a just government, nor is property secure under it, where arbitrary monopolies and exemptions deny to some people the free use of their faculties and the free choice of occupations, which are the means of acquiring property. I was in the 1790s. Now, flash forward to last year. When I filed a lawsuit in Missouri, I represent a Missouri entrepreneur named Michael Muni, who runs a moving company called ABC Quality Movers. Well, in Missouri, if you want to run a moving company, you first have to get a license. And when you apply for a license, the state notifies all of the existing moving companies and gives them the chance to veto your application. Now, surprisingly enough, existing companies aren't really eager to have new competition. What happens is when they object, then you have to go before a board and you have to prove to them that there's a public need for a new moving company. Now, how do you do that? Well, nobody knows. There are no rules in the law that provide to an explanation of what kind of evidence you're supposed to introduce or what the rules of procedure are or anything like this. It's just whatever the bureaucrats feel like. But even aside from that question, how would you go about proving that there needs to be a new moving business or any other kind of business? I first went to a Starbucks in about 1993, I think. I was on a trip to Seattle. A friend of mine said, you got to try this place. It's fantastic. You know, it's going to sweep the world. You know. it was just coffee to me, but you know. If you had been forced in 1993 to prove that there needed to be a new coffee shop in the United States, how would you have proved that? There were plenty of coffee shops. And yet it turns out America really did need new coffee shops. We know that because Starbucks is so successful. The only way to prove that there needs to be a new business is to try it and see if consumers like you. But in Missouri, you're not allowed to do that until you get permission from your own competitors. So we filed a lawsuit challenging the constitutionality of this Missouri law. And we argue that it violates the 14th Amendment to the Constitution. Now the 14th Amendment, I'm sure you know, guarantees your right to the privileges or immunities of citizens of the United States, your right not to be deprived of life, liberty, or property without due process of law, and your right to the equal protection of the laws. And we argue that this law violates all three. And what are the privileges or immunities of citizens of the United States? Well, the term privileges or immunities is a legal term of art, a technical term, that refers to the rights that belong to you by virtue of natural law or the common law tradition that has developed certain traditional protections for individual rights, like habeas corpus or the right to trial by jury or whatever. Right? And one of the oldest rights in the Anglo-American common law tradition is the right to earn an honest living without unreasonable government interference. The oldest case I've found on this subject dates from the 1340s, when a court in England struck down as illegal a monopoly on the sale of wine in London. But these cases really got off the ground in the early 17th century, Shakespeare's day, under the leadership of one of my heroes, the greatest lawyer of all time, Sir Edward Coke. Lord Coke, it's unfortunate how many people have forgotten his name nowadays, but Lord Coke was one of the truly great legal minds in history. He was Queen Elizabeth's Attorney General. He was Chief Justice of England before his opposition to the tyranny of James I led to his being fired from the court by James I, an incident which is sculpted on the front door of the United States Supreme Court building. And one of his leading things was, Coke was opposed to these royal monopolies, where the king would sell to his subjects monopolies on the sale of certain products. So like he would say, well, if you give me, £100,000, I'll let you be the exclusive business allowed to sell sugar in the city of London. And now it was illegal for anybody else to sell sugar except for you. There was a case called the Case of Monopolies, or Darcy versus Allen, where the Crown had given a monopoly on the sale of playing cards in London. It was illegal to make or sell playing cards, except for this one guy. And somebody else went and made and sold some playing cards. And he was brought up on charges and went up to the English version of the Supreme Court. And the court struck down the monopoly and said it was a violation of the Magna Carta's Law of the Land Clause. Now, the Magna Carta's Law of the Land Clause says you can't be deprived of liberty except pursuant to the law of the land. And that was the first of a whole series of cases. My favorite is the case of the upholsterers. It was illegal to practice a trade of upholstery without first having a license from the Upholsterers Guild. And this guy went into business doing upholstery, and he was brought up on charges for this, went up to the English Supreme Court, the Court of King's Bench, and by this time, Lord Coke had become Chief Justice of England. And so he said, why is there this restriction on people going into the trade of upholstery? Now, what did the Upholsterers Guild say? Did they say, well, the reason for this restriction is to create an artificial scarcity so that we can jack our prices up? It's nothing more than a monopoly scheme, a cartel designed to hurt consumers for our own benefit? Of course not, right? They said what these groups always say. They said, oh no, this protects the safety of the general public from bad upholstery, I guess, right? Right? You could sit down in a chair and it would be, there'd be something sticking out of it or something, And Lord Coke said this is ridiculous. Actually, he said, no skill there is in this, for a man might learn it in 6 hours. And then he said, in one of my favorite lines from any court decision, he said, unskillfulness is sufficient punishment. Right? If you're bad at what you do, customers won't buy from you, and that's sufficient punishment. As long as you're not out there hurting people, then there's no reason for the government to get involved in the first place. And these cases, there were several of them that came out around this time, that said every English subject has the right to earn a living without interference by these arbitrary government monopolies. Such free competition increases the supply of goods and services, brings down the cost of living and helps consumers, and it allows entrepreneurs to earn a living for themselves without and not become a burden on the welfare systems that were provided by English cities at that time. Now, when Lord Coke was fired by the King of England, he went into retirement and he wrote a series of textbooks called the Institutes of the Laws of England. And these were the textbooks that all law students read when they were studying in the Founding Fathers' day. So when you look at the history of people, the great lawyers of the founding era, people like Thomas Jefferson and George Mason or James Madison, actually Mason and Madison didn't become lawyers, but they still read and studied Lord Coke, John Adams, all these other, Patrick Henry didn't study law at all, actually. Patrick Henry actually studied law for 6 weeks before he stood up and took his test and was admitted to the bar, which infuriated Thomas Jefferson, who studied law for 5 years before he took the bar. Today, we only require real study for 3 years. So, but Jefferson, you know, scrupulously studied Edward Coke's books. Now, I've actually tried to read Coke, and it's not easy because half of it's in Latin, you know, and there's a very amusing letter from Jefferson when he was a 16-year-old law student saying, "I do wish the devil had old Coke." But as hard as he was to read, Coke was very solid on the principles of individual liberty. And he says over and over again in these books, every British subject has the right to earn an honest living at a common occupation without unreasonable government interference. And so the Founding Fathers adopted this idea, and they believed that you didn't just have a right to property, you didn't just have a right to your religious freedom, you also had the right to pursue happiness, as they called it, by putting your skills to work to provide for yourself and your family without government coming along and stopping you just to benefit somebody else. And these were the privileges or immunities of citizenship, according to a decision in the 1820s by a Supreme Court justice named Bushrod Washington, who was nephew of President Washington. He issued a decision that said, among the privileges or immunities of citizens of the United States is the right to earn a living. Now, flash forward to the end of the Civil War. In 1868, Congress was drafting an amendment that they hoped would prevent any future civil wars. And among other things, they said, no state should be allowed to deprive you of the privileges or immunities of citizenship. That was the 14th Amendment. And the idea behind that was at the end of the Civil War, southern states were enacting these laws like the Black Codes and whatnot that were preventing the former slaves from earning an honest living at a fair occupation and creating these monopolies and other restrictions to prohibit the former slaves from earning a living. Now, that was the law in 1868, and it only lasted 5 years because the first time the Supreme Court had to interpret the 14th Amendment, in the slaughterhouse cases of 1873, it erased the Privileges or Immunities Clause from the Constitution. Almost literally. What happened in that case was the state of Louisiana passed a law that said, if you're going to slaughter cattle in New Orleans Parish, you have to do it at one privately owned slaughterhouse called the Crescent City Livestock Landing and Slaughtering Corporation. That, surprisingly enough, but coincidentally, it just happened to be owned by members of the state legislature. Louisiana politics hasn't changed much. Well, so you'd have to imagine, like, if the state of Florida passed a law that said every automobile in Miami-Dade County has to be repaired at AMCO. Right. It would put hundreds of car repair shops out of business overnight. And that's what happened in New Orleans. And these butchers filed lawsuits, and they said, their argument was very simple. They said, we have the right to earn an honest living at a reasonable occupation without unfair government monopolies like this. It's a right respected by almost 3 centuries of Anglo-American common law precedent. It's one of the privileges or immunities of citizens of the United States. The 14th Amendment says no state can make a law abridging the privileges or immunities of citizens of the United States. That's what this law does, therefore it's unconstitutional. It's pretty straightforward. And they lost. In a 5-4 decision, the Supreme Court said, no. Now see, the Privileges or Immunities Clause only protects this very narrowly defined list of federal rights, such as the right to travel on the high seas. Right, because that's what the radical Republicans had in mind when they wrote the 14th Amendment. All those former slaves, this was their chance to take Caribbean vacations. So they were getting on those cruise ships and sailing around and having a great time. And the Arkansas Navy was stopping them out there. Ridiculous, right? The slaughterhouse cases cited none of the history, none of the scholarship, none of the debates or discussions or anything like that. Just by ipsy-dixit, by arbitrary fiat, the Supreme Court said, nah, we don't care. And since that day to the present day, with only minor exceptions, the Supreme Court has never enforced the Privileges or Immunities Clause of the 14th Amendment. So you can scratch that out. If you've got your little pocket constitution with you, just scratch it right out. It doesn't matter. So instead, we have the Due Process of Law Clause, and we argue that this law that abridges Mr. Muni's ability to go into business without getting permission from his own competition violates the Due Process of Law Clause. Now, that clause says government can deprive you of life, liberty, or property only in a manner that is consistent with due process of law. Of law. Not just any process, but due process. And not just any due process, but due process of law. What does that mean, of law? Well, a law, you know, we can debate, and philosophers have debated the question, what is law, for a long time, but there's general agreement on certain principles. That is, a law is the use of the government's coercive power in the service of some overall principle that benefits the public good, right? It's the opposite of law is arbitrariness. The opposite of law is, 'cause I say so, right? If the government comes and takes away your stuff because we say so, that's an arbitrary act, and it's not a lawful act. It would be a violation of the Due Process of Law Clause. The difference between law and mere force is the difference between reason and will, right? Law has some sense to it. It's comprehensive. It's rational in some way. It benefits the public, or it's understandable. But arbitrary force is simply because we have the power, we're going to do this thing to you. If you've ever told your kids, because I say so, you violated the 14th Amendment's Due Process of Law. Not really, because it's not state action, so it's all right. But if the government ever does something because I say so, that is a violation of the Due Process Clause. Now, how does this work? How does this constitutional prohibition on arbitrariness work in reality? Imagine a couple examples. Imagine that Congress passed a law that, let's say, required you to clean up your front yard or something, and the president vetoes it. And the next day, the sheriff shows up at your door and he says, you need to clean up your yard. You say, well, I don't need to clean up my yard. He says, I'm sorry, I'm going to have to put you under arrest. You would say, what's your lawful authority for doing so? And he'd point to this bill. You would say, that's not a law. The president vetoed it. If the president vetoed it, it's not a law. Which means if you arrest me, you're depriving me of liberty with a due process of law. Right? That's an example where there's some sort of procedural problem that means that what the government's doing is not lawful. But there are also certain substantive limitations, certain things government's not allowed to do, no matter what procedures it follows. For example, Congress shall make no law establishing a religion. So suppose Congress passed a law that said Scientology is the official religion of the United States. And the president signs it, there you go. And the weekend comes and the sheriff knocks on your door, he says, why aren't you in church? You'd say, I'm not a Scientologist. You'd say, yes, you are. Congress said so. And you would say, well, whatever Congress did, they didn't pass a law. Because Congress cannot make such a law. It can do whatever it wants with this thing, but it cannot make it into a law. Therefore, for you to arrest me under it would be to violate my right to due process of law. No matter whether the president signed it or whatever, because there's a substantive guarantee that's been violated by this law. And that's where there's an explicit prohibition in the Constitution. Are there also certain implicit limits on what government is allowed to do to us, even though they might not be written out in so many words in the Constitution? Are there certain principles, just common sense, ordinary principles inherent in constitutionalism itself that government's not allowed to exceed? Lawyers today say no. Lawyers today, on the whole, say government can do anything it wants to you so long as it dots the I's and crosses the T's. I'm reminded of one of my favorite lines from Tocqueville. He said, although lawyers love liberty, they value order more. And as long as it is the actual authority that is violating men's freedom, they are more or less content. Well, that's not the way the Founding Fathers thought. The Founding Fathers thought there were certain principles inherent in constitutional justice that prohibited government from doing certain things. They thought of government as kind of like a bank guard. Right? Imagine you own a bank, and you're afraid somebody's going to come and rob your bank. So you hire a guard. right? And he stands in the corner of your bank with his badge and his gun, and your problem's solved, right? Not quite. You got a new problem now, right? Because now you've let a man into your bank with a gun. And what if he took out the gun and robbed the bank himself? And if you fired him for that, you would say, well, you didn't put in my employment contract that I'm not allowed to rob the bank. You would say, duh. The whole point of hiring a guard is I wouldn't lose my bank, right? In fact, I'm happy to say I'm writing an article on this right now. And I ran across a case. The Florida Supreme Court actually faced a case on almost these exact facts. There was a case where a bank was afraid it would get robbed, so it hired a detective agency to provide them with a guard. And the guard secretly conspired with some third parties to rob the bank where he worked. And when he did rob the bank sued the detective agency because they said, well, your employee did this thing. Now, are there any lawyers out there? Right? Any lawyers out there? No lawyers? I thought the atmosphere felt lighter. No, they're just embarrassed to raise their hand. No. They're not under oath. They're not required to respond. So, under the theory, this theory is called respondeat superior, which is the idea that the employer is responsible for the acts of the employee. And the defense to respondeat superior is, well, the employee was acting outside the scope of his employment. So the bank sues the detective agency for providing them with a guard who robs the bank. And they say, well, you're responsible for the acts of your employee. The detective agency says he wasn't acting within the scope of his employment. And the Florida Supreme Court said, that's right, obviously, if a bank guard robs the bank for his own benefit, he's kind of gone beyond the principles inherent in the employment contract, even if the contract didn't actually spell out, by the way, you're not allowed to rob the bank. The same principle applies to government. If government takes out its gun and robs you to benefit itself, or to benefit the politician's favorite cronies, it has violated the very principle, the very purpose of having a government. Its acts are now arbitrary and are not lawful, and therefore deprive you of life, liberty, or property without due process of law. Now that theory is what lawyers today call substantive due process. And both conservatives and liberals are told that that this is a terrible thing. You should never, substantive due process is completely wrong. And they're completely wrong about that. Substantive due process is as much a part of the American constitutional order as separation of powers or the Bill of Rights themselves. And that was the understanding of the 19th century judges. I love 19th century judges. These judges, 19th century, law students today are taught that the world started with John Marshall and then just disappeared for a century until Oliver Wendell Holmes burst out of Zeus's head and arrived on the Supreme Court of the United States to save us all from capitalism. Okay, but actually all the great law really comes in between, right? People like Stephen Field, my favorite Supreme Court justice, the first Californian ever appointed to the U.S. Supreme Court, the only U.S. Supreme Court justice ever arrested for murder, who was a brilliant legal mind, dissented in the slaughterhouse cases, for example. Now, these 19th century judges took these questions very seriously, and there was a case in 1875, I believe it was, called Loan Association versus Topeka, and I love loan association. The question in loan association, if you filed this case today, you would be sanctioned for filing a frivolous lawsuit. What happened was these plaintiffs, the government of Topeka, took a bunch of tax money from some people and bought bonds in a private railroad. And the question was, is that constitutional? And the plaintiff said, all you're doing, this is not law, this is not a general principle to promote the public good. What you're doing is taking our wealth and giving it to other people simply because they have more political influence. That's arbitrary, and it violates the due process guarantee. And they won. The Supreme Court said, yeah, that's right. They said, to take from A and give to B is no less a robbery, simply because it is done under the forms of law and is called legislation. This is not a law. This is a decree under legislative forms. Now, if it's not a law, then it violates your right to due process of law, right? And that was Loan Association versus Topeka. And that was, there was a series of cases, loosely beginning about the 1870s or so, until the 1930s, that held that private property owners and businesses have constitutional rights that states are bound to respect. A shocking proposition in today's world. There was another case, an interesting case, that actually bears very much on my mover case. This is 1932. It's a case called New State Ice Company versus Liebman. What happened in New State Ice was the state of Oklahoma passed a law that said if you want to go into business, of course this is 1932, so this is before people have refrigerators. So this law said if you want to go to business delivering ice, making and selling ice, you first have to get permission from the state ice board. And the state ice board, of course, very soon falls under the control of the existing ice companies. And so you're not allowed to go into business making and selling ice without government permission, and you don't give the government permission. Then it went up to the US Supreme Court, and the Supreme Court struck this down as unconstitutional, as a violation of every person's right to earn an honest living at a fair occupation without unreasonable interference from the government. Now what happened? How is it that we went from a state like that, where the rights of America's wealth creators were taken seriously by federal and state courts, to a situation we now have where under Kelo versus New London, the government can take your home and give it away to Costco whenever it feels like it? The answer to that is the progressive movement. The progressive movement began in about the 1880s, 1890s, or something like that, and it basically continues to the present day. And progressivism was an intellectual movement made up of people like Oliver Wendell Holmes, John Dewey, Louis Brandeis, Jane Addams, people you're taught to revere in government-run schools. And they had these brilliant ideas for radically altering the American constitutional order. They actually had 4 primary ideas for how to change American law. The first one was, rights are just permissions. Now, the founders thought that you have rights because you're a human being, and that every government is bound to respect these rights. But no, no, no. For the progressives, rights are just permissions that government gives to you for government's betterness, for government's own purposes, for their own welfare. And when government has decided that you've made enough use of these rights, it can withdraw them from you. So take Oliver Wendell Holmes. I pick on Holmes with it because the man was the vilest human being ever to serve on the Supreme Court of the United States, with the possible exception of Roger Taney. But Taney occasionally wrote a correct decision, right, at Charles River Bridge. Holmes was a moral monster, and I'm convinced that the only reason lawyers consent to allow him to be considered a great American judge is because they don't actually read his opinions. Holmes literally believed there was no such thing as morality. It was all physical violence or governmental schemes that were employed to use physical violence and call it by another name. Okay? So he wrote a dissenting opinion called Abrams versus United States. Now, law professors in America's best law schools will tell you that modern free speech jurisprudence comes out of his dissenting opinion in Abrams. It's very famous for the phrase, marketplace of ideas. But if you actually read his decision in that case, one of the first lines in it is, persecution seems perfectly logical to me. He says, well, we don't persecute people though, because it's good for society to have a debate. So society gives people the permission to debate amongst themselves. And then, when they're done, we revoke that permission. So he also wrote the case of Schenck versus United States, very famous for the phrase, yelling fire in a crowded theater, right? And said you could send a man to jail for expressing himself. Does anybody read that case? Anybody know what Mr. Schenck was doing that he got thrown in jail for in that case? He was handing out pamphlets on how not to be drafted into the army. Yeah, it's just like yelling fire in a crowded theater. So that was the first great progressive idea, was rights are just permissions government gives to you. The second great progressive idea was government exists to make society nice. The Founding Fathers didn't think so. They said government exists to secure our rights. That's what they said in the Declaration of Independence. Jefferson, in his first inaugural address, said that the sum of good government is one which shall restrain men from injuring one another and leave them otherwise free to regulate their own pursuits of industry and improvement and not take from the mouth of labor the bread it has earned. But no. What with our modern ways? We've learned that actually government exists to make society pleasant to live in. And so the progressives came up with all these wonderful new ambitious plans for making society nice, like eugenics, segregation, the prohibition, the federal control over the money supply, zoning, which was invented originally to keep racial minorities out of white neighborhoods, or the use of eminent domain to redevelop neighborhoods that didn't perform up to the standard that politicians thought that they ought to perform up to. So that was the great progressive, the second great progressive idea was government makes society nice. The third great progressive idea was judicial restraint. Judicial restraint is the idea that when the government decides to violate your rights, courts should do nothing about it. Courts should just stand back and go, whatever. That's judicial restraint. I'm very sad to see how many of my conservative friends have adopted this absurd idea. The idea of judicial restraint, I'm going to make a poster that I'm going to put up on the easel. Great moments in judicial restraint, right? Plessy versus Ferguson. Louisiana passes a law that says blacks and whites are not allowed to ride in the same train cars. The court says, we're not going to be activists. We're going to stand back and let the democratic process have its way. Korematsu versus United States. The government throws the Japanese Americans in prison camps in World War II. Oh, well, we're not going to be activist judges. We're just going to let that happen. Right? Kilo versus New London. Great moment in judicial restraint. Government steals the lady's house and gives it to a private developer. Court says, we're not going to be activists. Democracy. Right? Or another Oliver Wendell Holmes masterpiece, Buck versus Bell. Anybody familiar with this case? Oh, you should all know Buck versus Bell. That was the case where Justice Holmes said it was perfectly constitutional for states to force women to undergo sterilization operations against their will. A case which has never been overruled. The court says, we're going to stand back. In fact, Holmes' language, he says, 3 generations of imbeciles are enough, end quote. This is the great hero of the modern American legal community. And then the fourth great progressive idea was the living constitution. Government changes and bends and stretches. It doesn't mean what it meant yesterday, blah, blah, blah. Right? And Justice Brandeis, who was only slightly better than Holmes, Justice Brandeis put all these ideas very well when he said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society. Remolded. Don't you love that word? Remolded. What a great euphemism for violated. Oh no, we're not violating your rights, we're just remolding your rights to meet society's needs. If it can be remolded, it ain't a right. It's a privilege. Imagine that rationale were adopted in the realm of religious freedom. Well, we're going to remold your religious freedom to meet society's needs. We have too many Baptists, so now we're going to make it illegal for you to be a Baptist unless you first get permission from the Catholics. Right? Of course it's ridiculous, and yet we allow that sort of idea to be adapted to in American law when it comes to other kinds of rights. Now these ideas, these progressive ideas, they didn't really control the courts at first. Holmes and Brandeis writing all these dissenting opinions, right? Until 1934. 1934 was the year the Supreme Court decided Nebbia versus New York. And I love to talk about Nebbia because it was such a stupid case. So, in New York, 1934, it's the depths of the Great Depression. You got about 25% unemployment, right? So, you got these bread lines, the soup kitchens and all this sort of thing. The solution to this problem is obvious. The solution is right there before the legislature of New York. If only New York will have the political will. Yes, we can. Yes, we can. The solution is make food more expensive. Duh. So they passed this law that makes cheap milk illegal. It's illegal to sell milk for less than 8 cents a quart under this statute. And the rationale behind this law was, well, if we allow free competition, the price of milk will go down until it reaches 0. And when it reaches 0, all the dairies will go out of business and then there won't be any milk left. Wow, that's brilliant. You win a Nobel Prize or something like that, right? So, and they pass this law prohibits the sale of cheap milk. And Leo Nebbia, a Rochester grocery store owner, sells 2 quarts of milk for 18 cents, plus gives his customer a loaf of bread. So he's brought up on charges for violating this law, goes up to the U.S. Supreme Court, and the Supreme Court said, yeah, you can throw him in jail for that. Because if the government wants to regulate the economy or private property rights, it can do virtually anything it wants to. This was the invention of what lawyers today call the rational basis test. The rational basis test. The rational basis test says a law has to be rationally related to a legitimate government interest. So, this test, now keep in mind, this test only applies when you argue that a law violates your economic freedom or your private property rights. If it violates other rights, like the right to travel, for example, then you get higher scrutiny. Courts will take that very seriously. They will really make sure the legislature is doing something right here. But when it comes to such unimportant matters as things that are actually listed in the Constitution, like private property rights, those things are not fundamental rights. Those, property, economic liberty, right? Those get rational basis scrutiny. Now, the only things you really need to know about rational basis scrutiny is it doesn't need to be rational, and it doesn't need to be the basis. The rational basis test means if a judge thinks a politician might have thought it was a good idea, the law is constitutional. I'm not exaggerating. That really is the test. Under the rational basis test, which applies, it applies to my moving case, right? So I go to federal court with my moving case. My client, Michael Muni, is standing right there. I say, Your Honor, this law is unconstitutional. My duty under the rational basis test, I'm required to disprove every conceivable rational basis for the law. What that means is I have to prove a negative, which, as you know, is impossible if taken seriously. Not only that, but even if I succeed in disproving everything the government says, the judge is required to come up with his own justification for the law. So, imagine that this were the rule in criminal law. You go to court and the judge says, well, yeah, I guess the prosecutor failed to prove the case against you, but I can think of a way you might have done it, and throws you in jail. That really is the test that is applied when we're talking about restrictions on your constitutional right to earn a living or your right to private property. Now, I worked on a case a couple years ago. My client was a guy named Alan Merrifield. He's a pest control worker in California, in Northern California. He's 67 years old, been in the pest control business for many years, and he doesn't use pesticides. He doesn't believe in pesticides. He thinks they're not very effective. People don't like them. They're dangerous, that sort of thing. And he doesn't deal with bugs. He only deals with rats, pigeons, squirrels, things like that. Mammals, things like that. Well, he's got this really cool device. This is really kind of funny. He got a device called the Bird Blaster. Sounds horrible, I know. I know it sounds horrible, it's not. It uses like radar or something to detect a bird landing on a building, and then it sprays compressed air through a flexible plastic hose. So it goes psh, like that. Scares the hell out of the bird, right? Bird flies away, he's not hurt, everybody's happy, right? Well, in California, if you want to install the Bird Blaster on a building, you have to have a Branch 2 structural pest control operator's license. And to get a license, you have to have 2 years of training learning how to handle, use, and store pesticides. And then you have to take a 200-question multiple-choice examination on the use, storage, and handling of pesticides. Now, I've read the examination. I'm actually under a court order not to disclose to you what's on that examination. But I can tell you what's not on that test. There's not a single question on it about pigeons. There's not a single question on it about the Bird Blaster, or about spikes or screens or anything like that. So, this law requires my client to shut down his business and become an apprentice for 2 years, learning skills he doesn't need, be tested on a 200-question multiple-choice exam, testing his knowledge of stuff he doesn't need to know in order to practice his trade. And it gets better, because the law only applies if you're dealing with pigeons. If you put the same spikes on the same building to keep seagulls away, you don't need any license at all. So, we filed a lawsuit. We argued this law was unconstitutional. We had the state's expert witness there in deposition. Now, this guy, this deposition witness, he was the guy who wrote the law. So, very interesting deposition. I said to him, now sir, this law requires 2 years of training in order to install spikes on a building to keep pigeons off of it. He said, that's right. I said, but no training at all to install the same spikes on the same building to keep seagulls off of it. He said, yes, that's right. I said, would you call this irrational? He said, yes, I would. And the government's lawyer said, can we take a break? So we come back from the break, and he says, I'd like to clarify what I said about irrational. I bet you would, right? He says, what I meant was, from the public's perspective, it's irrational, but what originally happened was there was a license that was required for everything. And then they were going to get rid of the license if you didn't use pesticides because you weren't a threat to the public, right? But those of us who already had licenses, we didn't want to face competition from newcomers. So we went down to the state legislature and we said, could you divide up the market so that we'll keep the pigeons, the rats, and the mice, they're the most common pests, and then they can deal with, bats and squirrels and whatnot. And I'm going, tell me more. I always tell people the hardest part about an imposition like that is not jumping up and going, ah, got you. I see. So we go to court and we say, Your Honor, it is an undisputed fact in this law that this law in this case, that this law is irrational. The state doesn't dispute that this law is irrational. And we still lost, because the rational basis test is so biased against businesses that even when the government witness concedes that the law is irrational, we still lost. Now, I'm proud to say that we won on appeal. We appealed that to the Ninth Circuit Court of Appeals, and the court struck down the law as unconstitutional and said government may not use occupational licensing laws simply for protectionism, simply to give favors to an established group at the expense of others. That's only the third Court of Appeals ever to pronounce on that question. The others are the 6th and the 10th Circuits. The 6th Circuit also said you can't use licensing laws just for protectionism. But the 10th Circuit said you can. 10th Circuit Court of Appeals in Colorado said, yes, government can use its licensing laws to protect one group against fair competition from others, even if the law has nothing to do with protecting the public safety. It's constitutional simply because the legislature chose to pass it. Now, the Supreme Court refused to take that case, and so that split is still on the books, and eventually it'll have to be resolved by the Supreme Court. But that is really an astonishing proposition. One case that might actually take this issue to the Supreme Court is going on right now here in Florida, where you have a law that prohibits people from calling themselves, truthfully calling themselves, interior designers, unless they have government permission. I'm sad to say that that case, the plaintiff in that case lost at the 11th Circuit Court of Appeals just last week. They're probably going to petition for rehearing and eventually ask the U.S. Supreme Court to take the case. But that case has another little twist to it, which is here you have not just the government saying you can't do this business simply to protect established insiders, but the government is basically confiscating words of the English language and saying you're not allowed to use this word unless the government gives you permission, which is clearly a violation of the First Amendment of the Constitution. Well, I shouldn't say clearly, because there are lawyers out there who will say, oh no, the First Amendment doesn't protect your right to commercial speech. I don't remember the Constitution distinguishing between those two, but the progressives did, so therefore it must be right. Now, getting back to my mover case in Missouri, I'm glad to say we just recently survived the motion to dismiss in that case, and there's a bill right now in front of the state legislature that would repeal this licensing restriction. It looks like that bill is going to pass. It doesn't have any opposition, and it's passed both the House and almost now the Senate. It'll pass any day now. Same thing happened in Oregon. We filed a lawsuit challenging an identical law there, and the state repealed that law also. They see me coming, and it just scares them. You know, it's like, oh, Sandefur filed a lawsuit. We're going to repeal that law, right? I wish. The bottom line, though, is that although I love suing the government, it's what I went to law school to do. I was like, what should I do with my life? I can sue the government. And here I am, right? It's the greatest job in the world. My day is not complete unless I've made a bureaucrat squirm. Even with that, you're not going to change things in the courts. Changing things for the better requires a broad-based attack, not just in the courts, not just in the halls of the legislature, but a cultural and social change. The progressives, it took them 50 years before they got the New Deal, right? And for us, it's going to be even harder, because we're fighting against an even steeper hill. We are working against a tradition that has always downplayed the importance of the wealth creators in our society, the entrepreneurs, the business owners, who put their liberty to work to create wealth that the government redistributes out of its broad-based compassion. Right? They have never been respected by any culture on earth until ours. And with us, it's still kind of 50-50. What we need is broad-based social and cultural change to restore respect for America's wealth-creating entrepreneurs. People who aren't asking for a handout or a bailout, but just asking for the government to leave them alone, to put their skills to work to provide for themselves and their families without unreasonable interference. And that's why groups like James Madison Institute are so important. Because while we can go to court across the country, we lawyers rely on expert witnesses that are provided by think tanks in various states. We rely on the research that's been done by these think tanks to go before legislative bodies to say, hey, you should repeal this moving law because look at how much it increases costs for consumers, things like that. Working in concert with one another, we can make a great deal of difference. It's not just the think tanks, it's people like you who go out and talk to your neighbors and your friends and your kids and your children's children and your children's neighbors' friends' kids about the principles of American constitutionalism, of individual rights, private property, and what this constitutional system was designed to protect. You know, the Constitution unambiguously says in the first sentence that liberty is a blessing. It doesn't say the same thing about government. And there's a good reason for that. Right? So it's up to you to restore those blessings of liberty. Thank you very much for coming out. I'd be happy to answer. Yes, sir.
From a long-term point of view, would you much rather have Missouri repeal that law, or would you much rather get a court decision on it? Now, I know you've got a client in there, so you have to bring relief to him.
The question is, would I prefer for them to repeal, or would I prefer to whoop their butts in court? We're on video here, sadly. Yeah, well, yes. I mean, because I represent my client in this case, I have to seek his best interests, and his best interests are a repeal, which I consider to be a victory. I mean, what happened? What we didn't see coming was the midterm elections. We had no idea that Republicans would sweep the state houses in all these states. I mean, Missouri, the Democratic caucus in the Missouri legislature can commute to work together. I mean, they can use the carpool lane. We did not see that coming. So it is a wonderful thing, but yes, I wish that there were, I mean, I'm in the business of creating precedent. That's what I exist to do.
You know, there are other types of laws. I mean, they'll get rid of the moving law, but they'll...
Oh, I know it. I know it. You know, the best example of that I remember is after Kelo, a lot of these states passed laws that they claimed, falsely in most cases, not in Florida's case, were protections of private property rights against eminent domain abuse. Alabama passed the very first restriction against the use of eminent domain for redevelopment on the same day that it passed an appropriation handing out $300,000 to the Alabama Film Council. So, you know, I was telling somebody earlier, I've got a comic strip on the door of my office. It's Calvin and Hobbes. I don't want anybody to read the comic page now that Calvin and Hobbes isn't in there. But Calvin is running around the house and he catches a fly. In the next panel, he's letting a fly go out of his front door and he's flying off. And next panel, he's turning around and walking very proudly back into the house as 3 more flies go over, right? This is my life. I ended the Missouri mover cartel, but we got Obamacare and the GM bailout. Right? So that's why it is a broad-based movement. But yes, I am in the business of creating precedent, and it's unfortunate that I won't get to create some precedent in this case. Actually, I did manage to get some precedent out of this on a technical matter. The question of whether I'm even allowed to introduce evidence under the rational basis test. There was a case in Colorado some years ago challenging a licensing restriction that the court dismissed the case on the grounds that as soon as the government articulates a rational purpose for the statute, the case is dismissed. Not that they lost the case, not that there was evidence received and the judge thought about it and ruled against you. No. The court found that you could not even introduce evidence the moment the government says the law is rational. All they have to do is say, yeah, Your Honor, law is rational. Boom, case dismissed. Right? That's the law. Well, that was the decision in that case. It's been technically overruled, but of course government lawyers cite it all the time. Anyway, so I'm glad to say the Missouri court actually ruled in a precedential decision against that. So I did get some precedent out of it. But yeah, I mean, I'd love to get the 8th Circuit to rule on protectionism as a constitutional matter. Anybody else? Oh, they're all, first of all, they're all staring at the skyline. And secondly, they're all, you know, dead from lawyer talk. Don't you want to know how Stephen Field was arrested for murder? I mean, yeah. Well, does that have to come to my next speech? No, all right, very quick. Stephen Field was appointed to the U.S. Supreme Court in 1863 by President Lincoln. And he had before that been on the California Supreme Court, where he had a feud against California Supreme Court Justice David Terry. Terry was notorious for having shot and killed California Senator David Broderick in a duel in San Francisco in 1858, whereupon he was obliged to resign and go south, where he joined the Confederate Army in treason against his country. After the war in the 1880s, Stephen Field was still on the court, and he was riding circuit through California, and he sat on a divorce case brought by an actress named Sarah Hill. Well, Sarah Hill wanted a divorce from her husband so that she could marry her new boyfriend, David Terry. And Field was the judge. And Field ruled that the divorce was invalid. And Terry, who was in the courtroom, unsheathed his Bowie knife and lunged at Field. He was tackled by the deputy and spent the night in jail and cooled off. And the Field goes back to D.C. and he says, you know, this guy's crazy. He's going to kill me. You know, And Terry's a very famous guy by this point. Terry had come back to California, served at the State Constitutional Convention of 1878. He was a very prominent political figure, and so was Field. Right? Field was on the U.S. Supreme Court. So they appoint a U.S. Marshal named David Neagle to be Field's bodyguard. Next year, they're riding circuit out in California again. Train stops near Fresno, and they get off the train to go to the restaurant. They go in the restaurant, and there's David Terry and his girlfriend, Sarah Hill. And Terry walks up to Justice Field. They're both in there. They've got to be 70 by this time. Terry walks up to Field and slaps him twice in the face. And Field's bodyguard pulls out his 6-shooter and burns him down in front of everybody. And Field and the bodyguard were arrested for murder. Field was immediately released and was never charged. But David Neagle was charged, and he petitioned for habeas corpus, went up to the U.S. Supreme Court. Field recused himself. But the court ruled in, I believe, a 6-2 decision that a federal marshal in the reasonable discharge of his duties cannot be tried under state law because of the Constitution's supremacy clause, which is still valid law to this day. So you got some real wild Old West history in the legal books there. Field served on the Supreme Court until, I believe, 1896, I think it was, making him, other than Justice William Douglas, the longest sitting Supreme Court justice in history. And one of his other very famous decisions was when he ruled the income tax unconstitutional, among other reasons, because it would lead to a war between the haves and the have-nots that was of increasing hostility until this nation shall collapse into a second civil war. That was before the 17th Amendment was passed. Anyway, that's my plug for Justice Field. Thank you very much. Oh, there was one other question. Yeah.
With so many cases like this coming up, other than the two that you just mentioned about TM and Obamacare, how did you find the moving company? How do you get these?
How we find cases, they often come to us. That's usually the case. People will come to us, but sometimes we'll read about it in the newspaper. In the moving case, I had done a very similar case in Oregon a couple years earlier, so this mover had heard about it through the mover newsletters, I guess, and contacted us because of that. We don't charge people for our legal representation. We're supported entirely by donations from people who agree with the work that we do, although about 1% of our budget comes from attorney's fees in cases that we win. So people call us, legislators sometimes call us when constituents have a problem and things like that. Thank you very much. I appreciate you coming.